Hey there, Sherry Kirchhoff here. Hopefully this trial run will work. I've never done a live stream to Facebook before, so here's hoping.
Good afternoon, this is Judge Torrington. Who's on the line, please?
Cheryl and Kirchhoff.
Sorry, two people were talking at once. Mr. Stetzer, did I hear you say your name, sir?
Yes, this is Thomas Stetzer.
Okay. And did I hear somebody else on the line?
Yes, this is Cheryl and Kirchhoff.
Okay, thank you very much. It's a few minutes before your hearing was set. Are you okay with me calling it early, or do we need to wait for whatever witnesses you may have called?
I'm ready to proceed.
I'm ready to proceed also.
Okay. So I'm going to go ahead and swear you both in so that any statements that you make will be under oath. If we get a loud feedback noise, I will have to ask that whoever is not speaking, including me, put themselves on mute to ameliorate that noise so that the FTR, which is the courtroom tape recorder, can actually hear whomever is speaking. It doesn't always happen, but sometimes, so we'll see how it goes. If you can both please raise your right hand. Do you swear or affirm the statements you're about to give are the truth and only the truth under penalty of perjury? Ma'am, do you so swear or affirm?
Yes, I swear and affirm.
Thank you. Sir, do you so swear or affirm?
Yes, I swear and affirm.
Okay, thank you. And I'll just advise the parties, we can only have one record of any judicial proceeding. The FTR serves in that regard, so it is not permitted to make separate recordings of the proceeding. Okay, so we are here today on a verified motion concerning parenting time dispute filed on May the 8th of this year by Mr. Stetzer. And with it, there was an attachment. Ma'am, did you receive the motion along with the attachment?
I received the motion, but I'm not sure which attachment you're referring to.
Yeah, let me open it up and I'll tell you what I've got here. Let me see, 1, 2. It's 3 pages. The first page is from Abby Pierce. It's an email, and it's dated, the top right corner says Thursday, February 13th, 2020 at 2:35 p.m. And once you locate that document, I'll move on to the next one.
All right. Would you be willing to move on to describe the next ones, and would you be willing to mail me a copy of the attachments you're describing, please?
The ROA reflects that this was mailed to you on May the 8th by Mr. Stetzer. I can ask, if you haven't received them, I can ask my law clerk to download them and email them to you now.
That would be great.
That might take a minute. Do you have them first? Let's confirm before I ask her to do that. The first page, top right corner, Thursday, February the 13th, 2020. Second page, from Thomas Stetzer to Abby Pierce, date Wednesday, February 19th, 2020 at 6:42. And then the third one is a letter from Family Tree. It says date March 11th, 2020, to whom it may concern.
I don't have those attachments. I've received all of the motions he's been filing every month, but I did not receive those attachments.
Okay. So my law clerk is part of this hearing with us. Do you have access to your email? If you want to say the email out loud that you want her to send it to, she can go ahead and send you those attachments from the May 8th filing right now.
Sure. That would be wonderful.
Yeah. What's the email address, ma'am?
It's kind of a doozy. It's opalobsidian1986 at Gmail. I'll spell it, of course.
Feedback. I'm going to have to ask the folks who aren't speaking to put themselves on mute so that I can hear the person that is speaking.
Okay. Sorry about that.
No, that's okay. It's just a challenge with the program. So I'm going to go on mute. Mr. Stetzer is going to go on mute. My law clerk, and it looks like we have call-in user 5. I don't know this is a public hearing like any other, but I'll need everyone who is not speaking to put themselves on mute so that we can actually hear the information that she seeks to convey about her email. Go ahead, ma'am, and tell us what it is.
All right, it's kind of a doozy, so I'll say it and then I'll spell it. It's Opal Obsidian 1986 at gmail.com. So that's O-P as in Paul, A as in Apple, L as in legalize, O, B as in Bobcat, S as in Sam, I as in Igloo, D as in Daniel, I as in Igloo, I as in Adam, N as in Nancy. So that should be Opal Obsidian, unless I missed one there. And 1986 at gmail.com.
Okay, thank you, ma'am. So, Ms. Lim, if you can go ahead, it'll take a minute because she has to download them electronically before she can email that. But if you can go ahead, Ms. Lim, and download the attachments that were filed with the motion on May the 8th and send them to that email address. And if you wanted to take yourself off mute for a moment, Ms. Lim, and tell us, do you need a repetition of the email?
No, I think I got it. Opal Obsidian 1986 at gmail.com.
That's correct.
Okay, thank you.
And you can just let us know, Ms. Lim, whenever it's been emailed, and then if she will know to expect to receive it shortly thereafter. Thank you for your assistance. Okay, so then the next issue, so we'll get that taken care of before Mr. Stetzer can rely on those exhibits. I need to make sure that you have them. I can't have anything, the court can't have anything the parties don't also have. So are either one of you intending to call witnesses other than yourselves this afternoon? And if so, are you asking the court to enter a sequestration order?
I do not have any witnesses, Your Honor.
Okay, thank you. How about you, sir? Mr. Stetzer, are you there, sir?
He might still be muted.
I'm here. I'm sorry. I hit the, you hear me?
Yes, I can. Are you intending
Okay.
to call any witnesses other than yourself this afternoon?
No, I'm not intending to call any witnesses, and just to make it aware of the courts, when the motion was sent to my ex-wife, it was stapled together by the clerk's office, so it was all put in an envelope in one packet and sent off that way. So it was all stapled. I still have the original. Not the original. I have my copy still here. It's all still stapled together. So
let me ask you this: did you actually mail it to her?
Yes, I did. It was all. Well, it was a total of 6 or 7 pages. The motion plus the 3 attachments. Yes.
Okay.
I sent the email.
Okay.
Thank you, Ms. Lim. And then, ma'am, let me know if you don't receive it in the next 5 minutes or so.
I'll
So,
let
Mr. Stetzer, it's your motion, so it is your obligation to prove the claims that you are making. So how would you like to proceed?
Just by my attachments, because it was court ordered for us to put in our applications and do our orientations through the Carla Center by X date, which I did, and then Carla Center informed me that it wasn't being complied with on my ex-spouse's side, so they sent me emails, and I continued on from there, and they continued to send me, and I put the attachments on the motion.
Okay, so your testimony is that the attachments are just as you received them. They have not been altered in any way.
Not at all.
Okay.
No, those are from the
Hold on.
Carla.
If he's going to just rely on those attachments, then I really need to make sure she has them before you test
Right.
it. So I'm just going to hold on, ma'am, and give you a minute to check your mail and see if you've received them.
I just got the chirp.
Great. So take a few minutes and look it over. And then just click on and let me know when you've had a chance to look through them, okay?
All right, I am looking at them now.
time that you need. That's okay.
Oh, okay. These are the attachments I've received on a previous motion. I thought you meant that this was new stuff. Yeah, I received this months ago, probably with his March motion. Or maybe April. But yeah, I do remember seeing them, although it has been months.
Okay, so you've got them in hand now and you've had a chance to look through the 3 pages?
Yes, Your Honor.
Okay, thank you, ma'am. Okay, so Mr. Stetzer, your statement then, so now that you've got it in hand, the court order is for supervised parenting time?
Yeah, I haven't seen my son for 1 year to the day. It was exactly June 22nd that I last saw my son last year. I had filed motions after that into July, but because our divorce was coming up in December, everything got delayed. Then pre-divorce here, pre-December when they were doing the investigation, I was criticized for not attempting to see my son, but every time a motion was filed, it was delayed till December 12th. I couldn't do anything about that. Those are 5 months that I would have loved to see my son had not the motions been forwarded to December 12th. But then, and then now it's been this. And just so you know, Your Honor, I have attempted to file the proper motion every time. I went to the clerk, to the pro se office. They give me the paperwork that I'm supposed to fill out. I fill it out. The one, I had told their copying machine wasn't working, so I had to go to the library. I dropped the motion off down at the clerk's office. I said, I'll be back in 20 minutes with the attachment. I came back 20 minutes later, about 15 minutes later, and they said they couldn't put the attachments on because they had already sent it in, so somebody had moved it, so they couldn't put the attachments. Just bring them with when I go to court. You denied that motion because the attachments weren't on it, which are the same attachments that are on this one. The next time when I got a motion, they gave me a different one for altered custody, and I had the motion, and they were the wrong motions for it, and you had asked for my therapy certification, which I now have, and my UA verifications, which I now have. I have those in my physical possession also right now, but now this last time, this is the motion I needed. This is the motion I needed.
Have you filed those things? Are you saying that you've also filed the UAs and the mental health piece?
Yes, I have my certification from Aspen treatment, and I have my UA results from my probation officer. I have them all.
Have you filed them with the court yet, sir? Because I don't.
No, I haven't. No, I haven't. No, those will be on a future mode. I have a pathway now. I kind of know what direction I'm going with all the dismissals. It's kind of laid down which direction I got to go. So it kind of helped me out to do it this way, but it delayed me seeing my son an extra 6 months. So, and so I mean, I forgot.
I just want to make sure that my record is accurate. But so what I'm hearing you say is you have not yet filed the mental health or the drug testing certifications. Is that correct?
Well, what do you mean file them?
Have you taken them in to the clerk's office in person or mailed them in?
No, I have them here in my hand.
Oh. All right. Okay, thank you, sir. Ma'am, do you have any objections to these exhibits? Sounds like you've received them separately from the facility.
Yes, I received them in Thomas's previous motion. Well, like I said, it was March or April when I received those.
Right.
And if I may say a couple things about them, you'll notice on the third email from Family Tree that they received my application for intake on February 21st. My son and I were both very ill the week of Valentine's Day, and so I was unable to fill out and send paperwork. And before that, my caseworkers in the apartment building were having an issue with getting the documents printed. So I turned them in. They received them the day after they sent the second email to Thomas saying that they hadn't gotten them yet. The day after they received my application, and a week after that, my Chevy broke down. The third cylinder had been blown the whole time since Mr. Stetzer purchased the car for me with the intent to keep me dependent on him while the vehicle needed repairs. Since Operation Freedom, was able to repair everything but the engine, which I was saving up for when it completely busted. So I am without a vehicle. I need to ask a friend to go get my groceries for me if and when she ever has time because she's moving now.
Thank you. This is the judge. So I just want to clarify. It sounds like you turned in your application, and have you gone in yet for the intake session, which is the next required step? Has that happened?
I've been unable to because my car broke down.
I apologize. You cut out. Can you tell me that one more time?
I said I've been unable to so much as go to doctor's appointments or the grocery store since my car broke down a week after they received my application.
Okay, so in the last 4 months, you have been unable or have completed the intake section. Is that what I'm understanding?
I've been unable to, yes. I've been looking for a vehicle, and with the stimulus that Andrew Yang got to everybody, through pressure in the government, I have something to use to look for a vehicle. Otherwise, I'd be flat busted broke. So I'm looking, but the only thing I've been able to find under $2,000, anything is saying, needs new engine, needs new transmission, tow away, do not drive. I haven't found an available option yet for transportation.
And ma'am, have you looked at public transportation?
The bus system takes incredibly long to even go to the grocery store. The drivers are finicky about whether they'll let me bring my grocery cart with me. And trying to bus from my home to the Family Tree Center in Lakewood would take an hour and a half one way. And then I'd have to hide somewhere and try and be safe during the visit, and then have to bus back another hour and a half while navigating the bus system with my 5-year-old son. And in addition, the fees that you've ordered us both to pay at Family Tree would take my entire TANF benefit. So I would have absolutely nothing to pay my bills, let alone do anything else my son and I need.
So I just want to be clear that it is the visitation facility that determines the cost. They are private entities, and it is up to them to determine the cost for the visits. Have you explored to see whether or not there are visitation facilities that might be more conveniently located to where you're living, or that may have, a different cost point, sliding scale, for example, or income-based?
Of the 3 places that Thomas selected for me to pick from, one of them was right in the middle of the downtown hood, so that's not safe at all. The one was at Carlos Family Tree, and the other one, I don't remember where that was because it's been, since January. I don't remember where that third one was, but it wasn't in Denver either. The only place that was actually in Denver was right in the downtown hood, where I don't go anymore. It's gotten really sketchy out there.
Your Honor, it's right by Union Station.
And you know how much
Right,
activity
right,
takes
okay.
place down there.
So, ma'am, let me ask you this. It sounds like there has not been compliance with the court order for supervised parenting time.
I've been unable to.
Are your suggestions about how to have the supervised parenting time go forward? What are your thoughts about how that can best be accomplished?
I'm actually, I've been writing petitions and legislation. One of my pieces is regarding parenting points and video visitation. If the non-custodial parent can prove, loving intentions, good actions toward the child, other assorted, good parent points, they would be assigned tiers. Like the first tier would be video visitation over Zoom or Facebook or etc. The second tier would be, the supervised visitation that has been ordered, and then moving forward from there. However, in the time since Operation Freedom, as I've reported before, Thomas has had my son's Medicaid shut off. That happened immediately after the previous visitation place closed our case. And nobody's telling me that the Easter Bunny did it, because it happened immediately after the visitation case was closed. And then I'm getting a call from my son's diaper supplier from, Medicaid benefit that they can't run the order of diapers because he doesn't have Medicaid. And when I called Medicaid to find out why, they said that his birth date had been changed by a parent. And that parent was certainly not me. It took me a month, the entire month of September, to fix that. So, and in addition,
the question that I asked you, in terms of what you think would work best for you, and to say that father can immediately begin having supervised visitation with a minor child in compliance with the court order, what are 3 things that you would suggest that the court consider as an alternative order?
I would suggest video visitation, but with the non-custodial parents' actions against myself and my son in this time, since he even paid a homeless guy $20 to make me sound crazy to CPS. I held Child Protective Services investigating my apparent obsession with my alien abduction experience. Tore up school, tore up everybody in my contact list to find out that it was a homeless guy who was paid $20 to make me sound crazy. He's had endless police at the door doing quote-unquote welfare checks. He's used the Talking Parents chat log to stalk and harass. My parenting points and video visitation system would be wonderful if my son's father wasn't a serial predator who's been attacking disabled women since 1979 and has brought 9 that I've seen, new slaves into court since January of 2019. This man is not obsessed with his love for his son. This man is obsessed with his ownership over his slaves. We have been attacked in this apartment building again with the same circle of friends who've attacked us previously. Only this time they added a blood to the group. And so the homeless coalition is seeking to move us to a new apartment.
What did you say?
The homeless coalition is seeking to move us to a new apartment ever since we were attacked in, racial warfare again, this time by a blood. The coalition is trying to get us moved, and Thomas is refusing to file his permission. I'm not planning to leave Denver Metro. My son has an individual education plan that will enable him to go to the wonderful elementary school that I found for him next year. And I need to stay in Denver Metro in order to continue taking my son to that school. Well, begin rather, since he starts in September. So I'm not going very far. Meanwhile, Thomas Stetzer has moved to Westminster, and you were concealing his address from myself and the process servers for several months while we were trying to get him served with the restraining order to add my son to it. I'm not allowed to move across town without road papers from Massa, but he could move across Metro to Westminster and conceal his address.
I appreciate your patience, sir. I will make sure that you have an opportunity to address the court again.
I'm going to forget half of it, but that's okay. I got, yeah.
You can make notes, sir. I'm sorry. I'm sorry. I was a little confused by that last statement. You have to have road papers from NASA?
For me, I guess.
In order to move across town.
That was for her. And did you say you have to have road papers from NASA?
That's what you filed, that I need to have his permission in court in order to move anywhere across town, let alone anywhere. And he's refusing to give that permission, even though our lives are in danger to racial attacks. And that can be confirmed on the Talking Parents chat log.
Okay, ma'am, I'm just going to note for the record that that is not what the court order says.
I have the page, it's in my pile.
Yeah,
I'm not going to argue with you, ma'am. Okay, so what I'm understanding from your statement, ma'am, is that you do not have any alternative proposals that you wish the court to consider in terms of a supervised plan, other than perhaps some type of video communication.
I would agree to that in addition.
Hold on, sir. I'm going to ask you for your thoughts in just 1 second. I know you've been very patient, but did I understand correctly, ma'am, the nature of your recommendation?
Yes, parenting points and video visitation would be the alternative, especially while I'm immobile. My leg's even torn up. I'm walking on knee pads now.
Okay, thank you, ma'am. So, Mr. Stetzer, do you have any other parenting time orders or arrangements that you want the court to consider implementing?
Well, I would love to physically be able to visit with my son as I've missed him dearly. I would not object to video visits in addition to that. And as for the statements over her moving, she had made a statement on Talking Parents that she was moving. All I had made the statement was that I just wanted the coalition to contact me to give me information so I know where she was moving. But I'm supposed to be able to know where my son was. And I know the court is aware that March 3rd that she had filed, or she had not filed, but put in a GoFundMe page to finance a trip for a U-Haul to take her, my cat, and our son to Canada, and that I was holding her in slavery by the Denver police, the courts, and Talking Parents. None of this was requested to be in our lives by me. I never made the request for the courts to be in our lives or for the court order for Talking Parents to be implemented in our lives. The only time I ever did welfare checks because I'm concerned about my son. We've had a very traumatic situation. I worked 6 days a week, Your Honor. I have not moved since November 27th. I'm at the exact same address, 3703 West 68th Avenue, Westminster, Colorado, since November 27th of last year. I've been in the exact same address. The only problem is my roommate and I, we both work, and we're very private individuals. Unless we know somebody's coming over, somebody knocks on the door, we don't answer the door. It's just, we're safe that way. We just don't do that. So.
This is the judge. I'm just going to note for the record that information was new to the court about the statements that you made regarding GoFundMe and some other things. That is not a record that is presently before the court. Sir, is there anything else that you wanted to request in terms of an alternative parenting time plan since this court has not complied with the current orders, or do you have any further requests or information to provide to the court?
I would like to be able to physically visit with my son face to face, and if it's able to be added for Skype on another day of the week, that's absolutely fine. I have no problem with that. I only had one request when I got put on probation, which I get off probation July 11th. But when I got put on probation, my probation officer asked me what my goals were. I only had one goal, to see my son. And I have yet to see him since I was on probation. That was my only goal. And with this other paperwork, I'll probably be using those as attachments on motions in the future with my certification and stuff. Is that what you meant?
I just wanted to give you an opportunity, sir, to make any additional statements that you wanted to make to the court or to provide any additional record. Or if you had specific requests, I wanted to give you an opportunity to share them with me.
Okay.
I wasn't seeking a particular answer. It was an open-ended question so that you could answer as you...
Okay. Okay, well, that's good because I kind of rambled on openly. So.
No, that's fine.
Yeah, that's fine. That's fine. Yeah, but yeah, I would have no problem. I do definitely. I want to be in my son's life. That is my only request, to be in my son's life. And it's a parental right. It's a civil right. And it's being violated. And it's being and this is going to take. Oh my goodness, this is going to take therapy. It's going to take counseling. I have no idea what my son is being told. I have no idea. I haven't seen him in a year. So, and I just want to be in my son's life. It's very simple. I've done everything that the court has asked. I've complied with every court order. I've attempted, and this is where we're at.
Okay, thank you, sir.
Yep.
Is there anything further that either party wishes to bring to the court's attention before I go ahead and make some findings and some orders?
Yes, Your
Do you have
Honor.
anything further to bring to my attention?
Yes, Your Honor. When Thomas mentioned something on Talking Parents about a GoFundMe and a U-Haul to Canada, that was complete perjury. I have not mentioned anything about going anywhere on Talking Parents except for moving elsewhere in Denver Metro with the Homeless Coalition's assistance. However, with the evidence that has been documented and recorded, the United Nations Refugee Board is willing and able to help us if we do need it. I am, however, trying instead of fleeing, which would not be peaceful and not provide a stable future for myself or my son. I am trying instead, as I have since Operation Freedom, to begin a jewelry and graphic apparel business that Mr. Stetzer used to traffic me to provide money for him. After Operation Freedom, I had $100 in jewelry and no graphics arts prospects. Now I am on Etsy because Thomas, as my owner, cannot tell me no, and I have just about $5,000 in inventory. However, I launched the first week of March, and with COVID, I've only made a $40 sale. So I am not in any position to go anywhere far. But in years, several years from now, I would be able to take my work wherever the prospect is best. It is most certainly not my goal to apply for refugee status anywhere, although we have been assured that we do qualify for it based on the nature of Mr. Stetzer's interstate human trafficking, rape at knife point, marriage at knife point. They used to have lock boxes in the Grant building where you could stash your weapons while you were in the building. If I did not marry Thomas Stetzer while I was pregnant with the child from his rapes, he would have slit my throat in the back alley right by the 16th Street Mall. Life was obey or die from Mother's Day of 2014 until January 24th of 2019. And I have on my YouTube channel the video of where I was able to dispose of a 3-foot by 4-foot by 4-foot Tupperware bin full of various sized blades, weapons, knives, swords, etc. that Thomas Stetzer was unable to move from my apartment when he was served with the restraining order in January. However, he did have an opportunity, as he said in court in December, to smash my son's phone and his Red Ryder wagon, which we have not been compensated for because you believe that he does not have them anymore, is what you said. Thomas Stetzer is a serial predator. He took me as his property and raped me to force me to conceive him a child so that he, as a single white male, could get into housing by having a disabled person and a child attached to him. Thomas has also somehow stolen my son's portion of Andrew Yang's stimulus. I only received $1,200. I did not receive my son's $500. Thomas was complaining on Talking Parents how some of his stimulus got taken to pay some of the arrears on the child support, which started on March 11th, was my first payment received, which was the day that Carlos Center said that I can't afford to do my visitation because I'm not receiving child support. That's when the payment started. My son's stimulus was taken. Thomas complained about his stimulus being partially, taken by the IRS for the child support. However, my representative at Child Support Enforcement Bureau has said that there have been no tax returns or stimulus filings in Thomas's Social Security number. So he is using somebody else.
Thank you both. This is the judge. I'm going to go ahead and make some findings and some orders now.
Thank you. Oh my goodness, thank you.
I'm just going to note for the record that I remain very concerned about the safety of this little boy, and
Yes.
I am going. Just give me a minute to finish. I remain very concerned about the safety of this little boy, and I'm going to follow up appropriately. But now I'm going to address the motion that is in front of me today, and based on the record that you've provided. So I want to just remind the parties about the language of the order, which is the first part I do find that they've complied with, which is the selection of a licensed supervised visitation facility. I will note that the father has filed sufficient documentation to demonstrate that he has complied and completed his intake. I will note that the mother has provided a credible record that she has not complied with her own intake and has done nothing thereafter to facilitate supervised parenting time for the father at a licensed visitation facility. So then that leaves the court with some options under the statute. Once it's been proven that the order is not being complied with under 1410 129.5, then the court, acting in the best interest of the child, can enter new orders or can sanction the non-complying parent. Given that the lack of financial stability for the mother and the minor child, I do not think ordering a civil fine, which is simply paid to the court registry and remains there, I don't believe that that is the most effective remedy, and I would be very concerned that it would negatively impact the minor child's ability to have his most basic needs for housing and food satisfied. I'm not going to do that. However, I do think that I am persuaded, either in his testimony, that she has no intention of complying with this court order to allow father and the minor child to have a relationship. So I am now going to remind the parties of the next section of the current parenting time orders. So, sir, you were entitled to file a motion with the court for unsupervised parenting time outside of the facility after you demonstrated that you had completed your anger management program through your probation, that you had completed the substance abuse and addiction evaluation and treatment that was required, and that you had been sober for 90 days, and that you were in good standing on any active criminal case. And so I hear you, sir, that you have the proof to file that you are in good standing, that you're clean, and that you've completed your treatment component. I don't have any proof of that because you indicated you haven't yet had an opportunity to provide that to the court, but I think that might be the next place that we look. If you can demonstrate that you satisfied those requirements, perhaps then the court is going to have to find that it is in the child's best interest for you to have unsupervised parenting time so that he can have some relationship with you at all. But I need to know that it's safe to do so. So I'm going to stay final ruling. I'm going to give you an opportunity to file the documents that you indicated that you had but in your possession, but that you have not yet provided to the court. I want to make sure that you have enough time to file them, and our clerk's office, which is operating with a skeleton crew right now because of COVID, has enough time to receive them and process them. So I'm going to set this out. Let's see, let me just give you a date in the calendar. I'm going to set the ruling and that's on July 8th. And sir, I will need you to mail a copy of those documents to the mother as well when you file them with the court.
Yeah.
Sorry, let me find it actually a better date. Give me 1 second. When do you think, sir, that you might be able to mail them in?
All I have to do is mail them documents into the courthouse.
And mail them also to the mother at the same time.
Okay, so I just send them to courtroom 311.
No, to the clerk's office, room 256. They receive all the mail for every courtroom, and then they'll stamp it and upload it.
Okay, and then mail a set of copies to her also.
Yes, sir.
Okay. All right.
Okay.
All right.
So
Yeah.
I'm sorry. You go ahead, sir. When is it that you think you might be able to mail them?
I can probably get that taken care of this afternoon. All I got to do is stop somewhere and get some copies of them.
Okay. So let's see. I'm going to give you the earliest date that I have as a return. So, ma'am, I'm going to give you an opportunity to receive these documents, and then you can each make comments to me about them before I enter orders. But I'm going to set this for ruling on Monday, July the 20th at 1:30, and we'll send you a notice of hearing. And you're going to call in exactly the same way that you did today. We will still have the same rules in place, at least through the beginning of August. So we have to do our hearings virtually if we can. So you will appear in the same way.
And, Your Honor, I do completely agree with the non-monetary sanctions, as I know times are tough, and I really don't want to take anything out of my son's mouth. I don't want to take a spoon of food out of his mouth. That was my concern, and I was going to express that I was recommending to not do cash sanction, anything like that. So I appreciate that.
Okay, thank you, sir. And it is very concerning to this court, the delay between father and the minor child having contact. The father has a right, constitutional right to a relationship with his child. Your son has a right to have a relationship with both of his parents. And frankly, ma'am, I am persuaded by your own testimony that you have no intention of facilitating a relationship between your son and his father, nor do I have any sense of confidence that you intend to comply with the court orders as they're written. So I am hopeful, sir, that you will have completed the work that you needed to complete through probation to demonstrate that it is perhaps possible to go to unsupervised time without endangering the minor child. So we'll return on July the 20th at 1:30, and we'll discuss that issue.
And sorry. Anything further before we conclude the hearing?
Yes,
Nope,
Your
I'm
Honor.
clear.
Okay, I heard Mr. Stetzer say no, ma'am. What did you say?
I said yes, Your Honor. In every motion that Thomas filed monthly demanding visitation, he filed that he requested me to pay fines, pay bonds, pay for classes, pay for this, pay for that. Except for the one motion where he demanded unsupervised weekends. In addition, I've been a stepmom in a parental custody situation, and that non-custodial parent was loving towards the child, and I was more than happy to drive back and forth every other weekend for her visitation. Thomas Stetzer, however, as I've already said, is a serial predator since 7 years before I was born. He raped me at knife point to get himself into welfare and housing, whereas you filed saying that I'm voluntarily unemployed to try and get alimony and child support. I'm the one trying to start a business to provide a future for my son, as opposed to having a master in a job force, as I'd been stuck with for several years previous. If my son's father was not such a dangerous individual, it would be wonderful for my son to have two parents. That would be amazing, except for this individual is so dangerous. And there is also log on the Talking Parents chat about him saying many, many times how irrelevant his child support payments are, how irrelevant his parenting classes are, how irrelevant his drug treatment and anger management are, how irrelevant all of his responsibilities are, while he's demanding his rights right now. And I am literally walking on knee pads. I can't at the moment. I am searching for a vehicle. I've been trying to get my car fixed since it broke down, and now I'm searching for another vehicle. If I get a dependable vehicle, I could do the supervised visitation, but as it is, I can't make it to a doctor appointment or a grocery store. I'm a sitting duck at this moment, as I've been since a week after Carlos got my application. I've been unable to do anything regarding it. My willingness is not a factor in my inability.
Thank you very much. I am sorry, truly, for the challenging circumstances in which you found yourself. So I'm going to conclude now, and we will speak again in July, and I am going to follow up on the appropriate stories about the safety concerns that I have in the interim.
My son has made extensive progress in life. He's doing so much better now that we're not
Thanks for
slaves.
using WebEx. Visit our website at www.webex.com.
She kicked me off the phone. She didn't like what she was hearing, and she kicked me off the phone. She really wouldn't have liked hearing that the Department of Homeland Security and the IRS are currently investigating both Jennifer Torrington and Thomas Stetzer for his actions in his criminal activity, claiming to be an outlaw biker, his interstate human trafficking, the rapes, the forced marriage, the 5 years of slavery, the taking our resources for his own because he is the welfare queen that Jennifer Torrington accuses me of being. She really wouldn't have liked to hear that. Thomas's actions and her complacency and support of his actions is completely disgusting, but it's typical of the Colorado court system, as it's typical of the United States court system. That is why I am documenting these events, and that is why I'm fighting alongside ADOS and the NAACP and any other human rights activism group I could find. I am also beginning my discrimination deterrent bureau due to the nature of the slavery and rape laws as they stand in the United States. To be able to document these atrocities is the only way to actually end them. When the internet comes together, like, oh man, you TikTok kids in Tulsa, oh, thank you to everyone. Thank you to everyone who participated in the foiling of Trump's Tulsa rally. That was one of the most beautiful things I've ever seen, except the birth of my son. But it is this level of online organization and contact and accountability that it's the only way to end this. Otherwise, injustices like this will continue to occur. Jennifer Torrington thought that she was the star attraction in the courtroom today. She was obviously not. The most important people in this court hearing today are you wonderful folks watching this video. I just hope it posts. God bless you and thank you. But yeah, waiting to hear about court in another month. Here we go.